Thank you all for being here. We are so pleased to have this session on guardianship and to have two very knowledgeable and talented presenters. We will first have Amy Hurst, who is the transition coordinator at the Utah Parent Center, and she will be presenting alternatives to guardianship. Amy enjoys helping families find the resources they need to thrive at school, home, and in the community. Prior to working for the Utah Parent Center, Amy spent several years in the legal field as a paralegal, specializing in corporate contract law. She spent part of her early career in the beautiful state of Illinois, where she became a Cubs fan for life. We'll forgive her for that. That's okay. And she earned a bachelor's degree from Weber State University in public relations and communication. And we also are so pleased and are grateful to have today Lisa Broderick Thornton, who, after Amy finishes her presentation, will present guardianship from an attorney's perspective. Lisa has been an attorney for 32 years and has helped hundreds of families with special needs legal planning, special needs trusts, and with securing guardianships for their children with disabilities. Lisa has been the president of the Utah Prader-Willi Syndrome Association for the last 15 years and serves on the Utah Parent Center Family Links Council. She serves on several advisory boards for organizations helping those with disabilities and has helped create two college-like lifelong programs for people with intellectual disabilities. And those are the Curtis Center in Lehi and University of Utah. Because Lisa has a 17-year-old daughter with Prader-Willi syndrome, she understands the journey of parents who love and serve a child with a disability. So I will turn the time to Amy. And Amy, I'll just give you a brief warning if you start to go over your allotted time, but I think you've got this presentation pretty well timed, so I'm not worried about it. And then when you finish, you can turn the time to Lisa. And Lisa, I will let you know when we are getting close to the time to wrap up. So I'll probably just give you about a 5-minute warning.
Thank you so much, Luann, and please do give us the warnings because I don't want to go over and take some of Lisa's time. I'm so grateful to be here with you today and to share this information. I have a 19-year-old who is in college and I have a 12-year-old. And so this transition age and the different issues we face is definitely something I'm in the thick of as well. So I'm going to talk about supported decision-making, which really goes hand in hand with guardianship. So that's kind of what I'm going to cover, and then I'll turn it over to Lisa for more information about guardianship. In 2009, Texas was the first state to support a pilot project run by the ARC of San Angelo, and it was created by their Department of Aging and Disability Services. Volunteers were trained to support people with intellectual and developmental disabilities in making decisions about their own lives. It was a 3-year project, and it was based on self-determination and assisting individuals with that decision-making. The changes were documented in those that were making their decisions, and they were those with intellectual and developmental disabilities that had increased self-esteem and self-advocacy. They had more engagement in decision-making and increased happiness. And so that was the first study where they decided that supported decision-making in some cases can be an alternative to guardianship. So I'm going to go over supported decision-making today, including power of attorney, healthcare supports, and financial supports. And then I'll turn it over to Lisa, who's an attorney, to talk about limited guardianship, plenary, which is full guardianship, and other legal solutions that you can use. So when our children turn 18, there are several options and several pathways they can take. Supported decision-making teaches independence and self-advocacy. It allows the right to try and fail and succeed with the dignity of risk. So we learn from our failures just as much as we learn from our successes. And it's really important that we realize that and realize even trying something out and saying, oh, I don't like this, or I do like this, I don't like working outside, or I love working with my hands, but I don't like working at a computer. Those are the things we figure out as we fail and succeed at different things we try. There are many formal and informal supports you can use when you're doing supported decision-making. Guardianship is also very important and critical. You can apply for full or partial to meet the specific needs of the young adult. It's legally recognized and protects those that need it the most. So as I mentioned, supported decision-making and guardianship go hand in hand. Some individuals won't need guardianship, and so the supported decision-making is here to help you with that. If you do take guardianship, then you still use supported decision-making to help the individual have their voice heard as much as possible. So they really go hand in hand, and they don't compete with each other. They work together. And so if we let individuals take, the risks that are safe, we don't want to take risks that are unsafe. Again, they can learn and grow from those and learn what works for them and what doesn't. So supported decision-making, what is it? Supported decision-making is often defined as supports and services that help an adult with a disability make his or her own decisions by relying on trusted friends, family members, professionals, and others. And there are some things to watch out for in supported decision-making. One of those is that third parties might not accept the decisions of the individual and their support system. For example, banks and doctors might not accept the decisions of the individual for various reasons. Supported decision-making also has the potential for exploitation because it's a non-formal situation. So to help avoid these issues, it's important to keep building skills of financial literacy, learning what a phishing scam is, what robocalls are, internet safety, self-advocacy, and so much more. So it's important to keep building those skills. And for everyone that's supporting the individual to watch out for and guard against exploitation and make sure that we have a safe circle of supports helping the person. So supported decision-making is really about focusing on strengths, interests, and needs, and really putting the individual in the center of everything. We all have different strengths and we can leverage those and use them. So what is self-determination? Self-determination is having the abilities and attitudes to make choices. It's also creating opportunities and using our skills. And it's doing it all with support. It's not doing it completely alone. It's having that support there and that guidance and helping to plan for the future. And of course, we all know that the family is the main support. The family is just so critical in this. We can support self-advocacy, practice making decisions, discuss types of decisions and how they can impact the individual, and we can discuss how our values, preferences, and needs influence those decisions. We can build the skills needed to succeed. So it takes a lot of time and practice, continually practicing social stories, role play, using pictures, and giving different options and letting people choose between them. And of course, using assistive technology for those that need it to help with communication. And we know as parents that we just know our kids. We know when something's off, we know when they need our help, and when they need us to help advocate for them. So there are two kinds of supports that come into play. Creating natural supports is very organic. We all create these supports, whether we realize it or not, and it really isn't just specific to having disabilities. We all have support. So when we need something, we find someone who can help us with it, especially if it's something we don't know how to do. For example, I'm not going to repair my own car because I don't know how to do it. So I will find someone that can do that for me. So as far as natural supports, who naturally connects with me? Are there family members, neighbors, parents, and friends? Who has a career in an area I'm interested in? So maybe you have a neighbor that has a career in the area that you're interested in or your individual is interested in. And what do I like to do in my spare time? Do I like to go to sports, Special Olympics? all those different kinds of things that fits one's needs. You can ask people to be a part of the team, and you can hold meetings and discuss what the young adult needs and how they can help. The second kind of supports are eligibility and paid supports. So these are eligibility based depending on what your child may qualify for. So there's support coordinators, support staff, possibly a job coach, doctors and nurses, voc rehab counselors, and teachers and counselors within the school systems. And those change as they grow as well. So in the college setting, there would be a disability resource center as well. So with supported decision making, the individual is the driving force over their own life. They can create a network of trusted family and friends for support and practice making good choices and learn from successes and mistakes alike. And then they also retain some of their rights that they might lose depending on the kind of guardianship that is gained, as far as voting, signing contracts, and getting married. So we have different ways we can use to support. We're going to go over just a few of them: power of attorney, healthcare supports, and financial supports. So a power of attorney is a legal document that allows one person who is the agent to act on behalf of the other who's the principal. The power of attorney states what powers the agent has. There are two types of power of attorney. There's durable and springing. Durable is effective on the date it's signed. Springing is effective when the person becomes incapacitated. There are different things you can include in a power of attorney. You can do statutory, which is property, financial, healthcare, or education. And the Utah courts do have a resource for doing power of attorneys. So there are some benefits to power of attorneys. A well-written power of attorney can be a helpful legal tool to allow someone to help handle personal financial matters without the need of more complex arrangements like a trust or a court-appointed guardian or conservator. And so a well-written power of attorney can protect against financial exploitation and abuse if the person is well trusted and they're using it. You can choose the agent. It's free or low cost, and you don't need a court or a judge. Our authority is outlined in the document, and the form is easy to access and use. So there are also limitations to power of attorney. And one of those is the principal has to have the capacity to understand what they are signing. So what that means is the individual that is going to be helped by the power of attorney and supported has to understand what they're signing, or you cannot put a power of attorney into place. If the document is challenged, you might have to go to court to enforce it. And the principal can choose anyone to be the agent, creating the possibility of being taken advantage of again. So that just goes back to having those trusted supporters and that help that we need as far as that goes. So healthcare supports include a HIPAA release form, which all doctors have a HIPAA release form that will allow supporters to continue to be involved in the care of their loved one. As long as the young adult is willing to sign it and knows what it means, it can be put into place. It will help if the person becomes incapacitated. It will not help, if the person becomes incapacitated. A living will is a written statement outlining the person's desires regarding their medical treatment and circumstances which they no longer can consent to treatment. If your young adult can understand and sign it, you can put it in place at any point. And then an advanced healthcare directive is a form that has been established in statute. A person can create it and it can work well for most people. You don't need a lawyer to create it. And again, it's not specific to having a disability. Everybody can put one of those in place. And then we went over power of attorney. So a medical power of attorney would make healthcare decisions for the individual. So the advanced healthcare directive does outline circumstances where another can make medical decisions for the individual, and it includes written instructions on the individual's desires should they be unable to make decisions. The healthcare power of attorney, you can assign an agent to make healthcare decisions for the principal under specific circumstances outlined in the agreement, and it can be put into place before anything happens, so you're protected in case of emergency. And again, the individual needs to be able to understand and sign it, so that's one of the limitations. Going into some financial supports, there are trusts, There's a Social Security income representative payee if they receive Social Security benefits, and financial power of attorney. So a special needs trust, it can be put into place whether or not you have guardianship, of course, and it's a legal agreement with a designated trustee. They manage the adult's assets, and you can still keep government benefits. It does require a lawyer, and money is set aside for the benefit of the individual, but they don't own the money, and therefore they won't lose SSI and other benefits. So it's there for them, but it's not something that they have ownership over. Social Security representative payee allows a third party to manage SSI payments for the individual. You do not have to be the guardian of the payee. Often it is the guardian, and they pay the monthly bills and other needs and make sure that those needs are met. Financial power of attorney outlines what the agent can do to support the individual financially, defines when it's in effect, and it can be immediate or it can go into effect under certain circumstances defined in the agreement. Now, there are some strategies that aren't legal documents, but they're more strategies you can use. And they include a joint bank account with 2 or more people, direct deposits, electronic deposits, and other electronic bill payments that take care of those bills automatically. And then also providing a limited spending amount. So having a credit or debit card with a limited amount that we're free to spend is always helpful, so that someone can have a little power over their money, but also not dip into anything that's needed for rent or for other reasons. And then also we're going to go into ABLE accounts next. So an ABLE account, the owner of the account is the beneficiary. The earned income by the account will not be taxed, but they must be made using post-tax dollars. So they had to have already, deposits must have already been taxed. It helps with living expenses. Typically, only the beneficiary of the ABLE account contributes funds to the account. Funds contributed by others may be required to be paid back to Medicaid if they remain in the account upon the beneficiary's death. So you just want to be careful with who contributes to the account so that that money isn't lost in the event of the individual's passing. So some advantages to overall supported decision-making in all these options are that studies have shown that those with disabilities that make their own decisions have greater self-determination, more independence, are better integrated into communities, they're healthier, better able to recognize and resist abuse. And so some of the things we can do is honor an individual's curiosity, share power with the person in a partnership and help them. Language matters. Talking to an individual with high expectations and, you know, what brings out the best in this person and how can I support this person? And also beginning as early as you can. It's a lifelong process. It's not something that just we flip a switch at 18 and it starts. And so beginning as early as possible is also very helpful. And so I want to thank you guys. We do have Transition University classes on the events page of the Utah Parent Center calendar with more in-depth information. And so we'd love to have anyone who's interested to attend that as well. And I'm going to go ahead and hand off to either Luann or Lisa so that we can switch over.
Great. I thank you so much. You were right on time, so I didn't interrupt you with a time reminder, but we do have a question, and I will let you decide if you want to answer it, or if you, since Lisa is such an expert, maybe she will want to answer this one as well. But we have a question in the Q&A. Roz would like to know, with the special needs trust, who sets up the money account? Does the bank do that, or the attorney, or the responsible person for the trust, the trustee or the family?
So who sets up the account? Lisa might be able to help with that.
So typically, I mean, that just depends. If the parents want to have an account and designate money pointed to that special needs trust during the time when they are alive, they can do that and open up an account and put money in there. But 99% of families point assets toward the special needs trust, but nothing triggers until their death. And so typically the trustee of the special needs trust will open up the account and deposit the money there, or the assets.
Perfect, thank you. So I am answering questions in the chat if I know the answers, and if not, I'm just saving them until the end. So with that, go ahead and begin your presentation, Lisa.
Thank you, Luann, and thank you, Amy. That was wonderful. And special thank you to the Parent Center. When my daughter Kate entered into high school, here she is a little bit younger, the Parent Center completely saved our lives, literally. And we owe them a huge debt of gratitude. And I want to encourage everyone to join in at the 6:30 presentation tonight with Dr. Bennett Murphy and my two daughters, Jane and Emma, who have done significant research on sibling health when you grow up with a sibling with special needs. And I think we all need to pay very careful attention to the well-being of our other children as well. And I first want to say how blessed we are to have someone with special needs in our family, and how much we learn and grow from them, and how our family is completely different because of our Kate. Our children volunteer, as you will see tonight. They reach out, they know how to help, they're more empathetic. And then there are lots of families in your community who are crumbling, and they need the very help that you could provide. And so I encourage all of you to get involved and help in any way you can. And as Luann mentioned, I wanted to give you a slide of the 2 college programs that we've helped get started. And if you want to attend, or if you want to help us in these endeavors, there's the slide for that. As parents of children with special needs, we hope that our children will live a long, happy, and enjoyable life, but that we'll live one moment longer. And as long as we are living, we take very good care. We go to unending therapy, IEPs, and do everything we can, hundreds of doctor's appointments to make sure they have the best life possible. But many of us don't plan well for when our children are turning 18, and most of us don't plan at all for when we are no longer here. And I'm going to talk in this presentation about legal guardianship, but I have several slides at the end that include other legal protections for your child and your family. And so I want you to look at those, and I will also stay longer after they do the prizes for anyone who wants to ask any questions, but I'm happy to take calls or emails with those questions as well. So let's talk about legal guardianship. If your child will need extra help at age 18 or older, you should seriously consider getting legal guardianship for your child. When your child turns 18, they're presumed to be an adult and be competent to handle their own lives unless a court determines otherwise. And this has many implications for you as families. For instance, you might have already found out that an insurance company won't talk to you about health issues, and a doctor shouldn't talk to you after they turn 18 because of HIPAA regulations. And if an adult with disabilities runs away or takes off, some law enforcement agencies won't look as quickly. And I had one family tell me about a 21-year-old daughter with cognitive deficiencies, had a man take her to California and say he was going to marry her. And the family called the police, and the police asked if they had guardianship, and they said no. And they said, well, she can do as she pleases. So serious consideration needs to come into play to determine whether you should seek guardianship of your child with disabilities when they are reaching the age of 18 and older. And with guardianship, that allows you to continue to act with legal authority as a parent, just as you do when they're 5 years old or 10 years old. So what is a guardianship? A guardianship is a legal proceeding where someone, usually parents and siblings, petition or ask the court to determine that the child is unable to make their decisions because of disability. And the court issues a document called letters of guardianship. And this document allows the parents or the petitioner the legal authority to continue in that decision-making role as parents. So I think the biggest questions that most parents have when they call me is, do we need guardianship? So from a parent's perspective, how do you know? I often ask parents, will this child be able to handle money safely without being taken advantage of? Will they be able to go to a doctor's appointment and make reasoned decisions about medical care? Will they be able to decide appropriately about their education needs, about their need for therapy, Will they be able to provide for their basic necessities and earn enough for their food and shelter and clothing? Will they be able to decide where to live? And they be able to take care of themselves independently? And if you can't answer these questions, it might be great to consult with your school teachers, your child's school teacher, or physicians, the school psychologist. But do note that if you wait until after your child's 18th birthday, a lot of the information that they could provide you, they cannot. And you might have to get releases signed to get the information. And also beware that many people and many professionals, perhaps well-meaning, might give you advice you may not agree with. There's many out there that consider being an adult a sacred right, and no one should ever take that from a child, no matter the disability. And I see many parents also who don't really see their children clearly. They've been with them forever, and so this is just Kate. When I begin a conversation with them, they tell me the amazing things that their children do, and they're questioning whether they even need a guardianship. And rightly so, we love to see their progress and we celebrate each success. However, as we drill down and ask the questions, then oftentimes it becomes clear that the adult really does need extra help that a guardianship could provide. The decision to pursue guardianship is a personal one, but here's my commentary on the issue. I want my Kate to fly as high as she can go and accomplish everything she can and live her life to the fullest. But I want a strong safety net under her. So if she falls, she's not going to hit the concrete. So I have the legal right to step in and protect her from other people. And as Amy so aptly provided in her presentation, if your child doesn't need guardianship, this slide also lists several of the avenues that are available and tools that exist with options besides guardianship. And if you want to set those up, an attorney can help, or as Amy pointed out, many of these options are online. So the first thing that a judge needs to decide is the person incapacitated? And you would need to show with clear and convincing evidence that your child lacks the ability to provide for their own necessities, such as food, clothes, shelter, and safety, or that they cannot receive and evaluate information or make and communicate appropriate decisions. Incapacity means they lack the tools for financial protection, physical health, and self-care. And the clear and convincing evidence that you would present in a guardianship is generally a letter from a doctor stating as much, and the school psychological report that shows where your child functions, which usually has something like a Woodcock-Johnson test or something like that that's listed there with the scores. So who can serve as a guardian? Generally, parents ask the court to allow them to serve as guardians. And can I just say, from a parent perspective, how hard this is for me to swallow. I've killed myself to take care of Kate for 18 years. And then I have to pay the court to go through the legal hassle of being allowed to continue to take care of her. And this is one reason why I'm up at the legislature every year trying to get changes. We got the filing fee reduced from $360 to $35. And we got it so most of you never have to hire an attorney for your child. And we're working on getting caregiver compensation to become a permanent option under DSPD. And we're trying to get it changed so if you name a sibling of the child as a legal guardian in the legal proceeding, that they can still be paid under DSPD. So if you want to help us in those efforts, please email me with my email address on my slides, and would be happy to have your help. Most families have both parents petition to be guardians, and then again, an older sibling is often named in case something happens to the parents. But as I stated, if they're a DSPD employee, they will not be able to be paid anymore. If there's a legal dispute over who should serve, for example, if the family isn't all on the same page, Utah law sets priority of consideration of the people that will be able to be considered as guardians, as outlined in this slide, but this doesn't happen often. So the next thing is, some parents don't want the legal hassle of preparing all the pleadings and appearing in court without help. And so they don't want to take the risk of having any mistakes made. And so this is one of the things you have to address, is if you want to do this yourself or if you want to have an attorney help you. And I do several of these a year and try to make it as easy as I can on families. However, you can represent yourself, and the court has a website that I've listed here where you can prepare forms and figure out how to do this. The next question is, do you need an attorney to represent your child? And you do not need an attorney. And there's basically two things you think about is, first of all, does the child have more than $20,000 to their name, which hopefully none of you have that if they are incapacitated, because that shouldn't be happening for SSI or DSPD or Medicaid. Find a way to get that money spent or figured out, but you don't want to have that. And then he or she just needs to be your child, biological or adopted. And then you do not have to have an attorney for your child. The statute lists other factors, like the court has to appoint a court visitor. You have to wait for an attorney to volunteer to represent your child, but those are not being enforced in the courts. So really, it's just the two issues that you have to worry about. And where I practice, mostly in Utah County, Salt Lake County, Davis County, all of those counties where I practice, the courts are not requiring those other court visitors and attorneys to volunteer. But you do have to have an attorney for your child if, for instance, you're a sibling and no parent is applying, or you're a grandparent, or your child has more than $20,000. So as part of the guardianship process, if you decide you want to go down that route, at about age 17, you should ask the school for the most recent psychological evaluation. And if it's 3 or 4 years old, you're going to want to get a new one. And you'll want this for supplemental security income as well. The school can do these about every 3 years, and even more often if you ask. One thing I've noticed is try to get the school psychologist to give you a full report rather than a summary report. So you can also use it for applying for supplemental security income. The school psychological reports are getting skimpier every year, and they're calling them summary reports, and some are 2 pages with just a table. And this is causing families a lot of trouble with supplemental security income, but I haven't found trouble with those with guardianship. And then next, about 18 months after, 3 months before your child turns 18, have a name of a doctor or a nurse practitioner or someone like that that sees your child who can sign the letter stating a child's disability and need for guardianship. And I draft these letters for my clients, so I make sure that they meet the clear and convincing evidence standard that the court is looking for. And then you'd want to have the doctor sign the letter and put that on their letterhead. So whether you're representing yourself or having an attorney help you, you need to draft a petition that includes that psychological evaluation we talked about, that includes the doctor letter, and includes an estate value worksheet that says how many assets your child has, and include those as exhibits in your petition. And you file that petition in the county where your child is residing about 5 to 6 weeks before your child turns 18. Note that the judge will not hold the guardianship hearing before your child's 18th birthday, because until your child turns 18, you are the legal guardian. One thing to think about, I had a mom call me on a Thursday and said, my son's having major surgery on Monday. He's already 18. Can you help me get guardianship? And there's no way that we can get you guardianship in 2 days, and 2 of the days being the weekend. So you do need to start in advance, especially if you have something coming up. My neighbor was hit by a car and no one had guardianship over him. He had special needs, and it was a nightmare trying to negotiate that injury when he was over 18. Next, you pay the filing fee, $35. Again, it used to be $360, so I'm proud of that. You scheduled the hearing for right after your child's 18th birthday, or the first available date. And I've just listed the typical times for Salt Lake and Provo for those counties, Utah County and Salt Lake. And then you have 9 more pleadings that you file with the court, and they're listed here. I won't go through those, but you can see those here. So the other assignments for the guardianship process is you will need to take a short online open book test that I've listed the site here. It's easy. And then you file a certification that you've done that. And then you need to have someone who's 18 or over, or a constable hand the petition and a notice of petition to your child, and then sign a return of service in front of the notary. So then after you've scheduled the hearing, you bring the adult with disabilities to the hearing along with everyone else who wants to be a guardian. If the paperwork is in order, it's a quick hearing. It runs smoothly. The judges that I work with are very kind. They typically don't ask a lot of questions, and if they do, they're nice, easy questions like, are you willing to continue to care for your child? The hearing process can be stressful for your child, so it's nice to prepare them. The wonderful thing about right now is with the COVID restriction, the hearings are being held on WebEx, so you can do this from your living room. So it's the easiest time I've ever seen to have guardianships completed, so you might want to work on it now if you can do it. After the hearing, you would go down to the clerk of the court's office and you would get a certified order. And in my orders, I always list that you're allowed to charge rent. You have a court order that you can charge rent for supplemental security income. And I encourage you to get at least 4 certified letters of guardianship after the hearing. They're about $5 each right now. And that is the document that you would show that you are legal guardian. And I encourage you to give a photocopy of these if the agency will take it, as you would need to go back to the court if you run out and pay for those, and that's a hassle. Unless you are a parent, which we've been fighting that as well to make this so parents don't have to do this. But if you're not a parent, you do have to file an annual report that states their financial status. And if it's actually not as horrible as it sounds, and it's done online. And so after the first report, they save your information, so it gets easier every year. But as a parent, you don't have to do this. Utah County used to make us do that if you listed a sibling and parents, but they've stopped doing that now. If there are objections to a guardianship, then here's what you do. So all interested parties are mailed a copy of the guardianship petition, and so they can object in writing or they can come to the hearing and object. And if there is an objection, then it gets moved to a full calendar where there would be witnesses and a full hearing, and then the judge would make the determination of whether a guardian should be appointed and who those guardians would be. And again, this doesn't happen very often. Utah law favors limited guardianship. And if you do this, make sure you include all the areas that are needed. Medical decisions, education choices, where the adult child lives, financial decisions, the care and comfort, clothing, vehicles, habilitation is what they call it. And that means your therapy, training, treatments, and especially include end-of-life treatment, end-of-life decisions. I generally encourage families to seek full guardianship in cases where their child struggles with capacity. Some of the limited guardianship orders I have seen cover everything imaginable, but may not cover that one item that you need down the road. And then you would need to go back into court and file documents and have another hearing to add that option that you left off. For instance, one family I saw didn't include any end-of-life directions in their limited guardianship, and the parents had divorced, and there was a bitter battle over where that adult with disabilities would be buried when he died. Typically, in my cases, I encourage families to seek full guardianship. When I asked the clerk of the court that handles the most guardianship cases in Utah, she reported that 90% of the guardianship cases she sees are all full guardianships. And if there are no objections, I've not seen a judge not grant a full guardianship. But limited guardianships have their place, and they're rightly employed when an adult who functions at a high level can make good decisions for themselves. So some of the powers and duties of a guardian. The court order, if it's limited, will list these. If you have a limited guardianship, the order will list what these are. If it's a full guardianship or plenary guardianship, then the guardian would have such powers as having the custody, establishing residence, providing education and training, deciding on clothing, furniture, vehicles, estate planning documents prepared, receiving money for the ward, and providing annual reporting if you're not the parent. This is one question that most parents have, is they worry about liability if their child does something that hurts someone or property. And many worry about this, but a guardian is not liable for the acts of an adult child. A guardian is not liable for reasonable actions that they take in the best interests of their child with disabilities. They're only liable if they're personally at fault, or if the child is creating damage because of their carelessness. And then there's also a penalty if you don't file the annual reports if you're not the parent. So I've included many more slides about other things that you would need to consider. And I'm happy to talk about these until Luann tells me to stop. So to protect your child, you should have letters of guardianship. You should get a special needs trust. The earlier, the better. And you still need an ABLE account if you have a special needs trust. You should have a power of attorney for the parents, advanced healthcare directive for the parents, a will for parents, revocable trust for parents, and life care plan or letter of intent for the child. Again, a special needs trust provides extra money for your child that does not count against them in their $2,000 limit in order to qualify for such benefits as DSPD, SSI, Medicaid.
Lisa, we'll need to wrap up in about 3 to 5 minutes.
Okay.
Thanks.
Again, ABLE accounts are great, but if your child is on Medicaid and there's money left in that account, Medicaid will take it. And so don't put your money in there. If your child's working and is going to lose benefits because of that money, they can put up to $15,000 a year into that account, up to $100,000 without affecting their eligibility. And then these are just some of the documents that you should have as a parent to go along with all of the other legal documents that are there. And again, one thing to just keep remembering, if you die without your estate planning, your child will inherit from you and will inherit at least $2,000. And so that would make them, their benefits of SSI, Medicaid, and DSPD come into question, and they may lose those. So that's why you want to get this estate planning set up and a special needs trust for your child, so that does not happen. A letter of intent is a fun thing to have. It's not a legal document, but it's a template where you list all of the doctors, all of the people who help you, your hopes for their future, all different kinds of things. So if something happens to you and you have a guardian take over, then all of those things are outlined for that person, so they can just pick things up and run with it. And a life care plan is a very similar document that, while not a legal document, it's a great thing to put into your plan. And I can send you templates for these if you email me. Like some people have a special song they sing when they're bathing their child that helps them cooperate. You've spent a lifetime learning about your child and what makes them sing and dance through the day. And it would be great if you would write these things down. So if someone had to pick up that binder and start taking care of your child in your place, that you would have those things ready to go and they wouldn't have to start at square one. And the other just last thought is everything changes, your circumstances change, and all of these decisions, all of these, let's say you decide not to get guardianship right now and then things change. You can then go back to court and get guardianship. If you set up your legal documents and you pick someone to be the trustee of your child's trust, you can change that. There's always ways to change. So it's nice maybe the first of every year to sit down with your documents and see if they still represent what your wishes are. So that's it. I love working with families of children with special needs. They're wonderful parents. And I just honor all of you and I applaud you for this journey that you're taking and for all the great good you're doing for others. And thank you.